Let's get some analysis. We're joined on the line by UNISA Professor Emeritus Shadrack Gutto. Shadrack, thank you for being with us. A lot of people thought South Africa really had no justification, no leg to stand on for being a signatory to what's been agreed to around the ICC and then not arresting al-Bashir. But some others say we actually presented quite a compelling case today. So let's start there. What do you think of our government's argument before the Hague?
Well, to start with, I would say that South Africa messed up procedurally. First of all, South Africa is not just a signatory, it is a state party, which means we ratified the Rome Statute. We didn't sign it, we ratified it. But also we domesticated it. In other words, we made it part of our national law. So we are dealing here with a national law and an international law. And I think that South Africa is confusing the public and the international community by just saying, well, we signed it, but otherwise it is not a law which is applicable nationally. So the court cases that we are dealing with here is where South Africa is violating its own law, but also international law. So that is where we have a problem as a country. So we should come out and say we messed up in our understanding of our relations to the Rome Statute of the International Criminal Court. So that is the main fundamental starting point, which we are not bringing out, or the government or the state is not communicating to the public to say, we are sorry, we didn't do our work properly. We now realize that we made a mistake, and from that, in the future, we are going to behave. Secondly, if we deal with the question of diplomatic immunity for certain people, the Rome Statute does have a provision for that, but it calls for the state involved to be able to communicate with the International Criminal Court to be able to indicate whether it will be exempted from handing over a person who is under prosecution or is being indicted. And we did not do that. So that's the second problem that South Africa went through. So instead of trying to, really, make South Africa look like some banana republic, we should come out and indicate those two major points, and we are not doing that. And from that point of view, I think there's a problem in the country in terms of its understanding of its laws, the Constitution, and international law.
Well, prosecutors from the ICC not happy. They're talking about referring this to the UN Security Council. How serious is that, and what can actually be done to South Africa for not taking this action?
It will be more damage to the South Africa's image internationally if this goes to the UN Security Council, because the al-Bashir case was really referred to the International Criminal Court, one of the very few cases which were referred by the UN Security Council. Other cases that came from Africa that are before the International Criminal Court were sent there by state parties. And from that point of view, I think that South Africa will suffer even more in its reputation as a country that believes in international law and rule of law and so on, if this is referred to the UN Security Council. All that it will do is to reaffirm its own resolution. And I think it is an argument which is weak, and we shouldn't pursue that line. If I was advising our government, of course, the government sometimes doesn't seek independent advice. It goes with its own advisors or whoever they choose from outside, who really do not understand the operations of international law to advise them. So I really hope we don't go through that route, because it will even make our situation worse than it is already.
All right, presumably what you're saying is that we should comply, but government has made it clear it wants to leave the ICC. It doesn't want to be part of the Rome Statute anymore. The courts are saying no. Can we really stay in this limbo where we're meant to be doing something, but there's zero political will to be part of this?
Well, what you are indicating is a third area of contention that we have here, and that is that our courts, not international courts, but our own courts, have already indicated that that is wrong, and therefore government will not succeed. We need to go up to the Constitutional Court to indicate that our government is violating its constitutional rights, because under our Constitution there are provisions which deal with how we ought to abide by international law, and already the courts have indicated that really there was a mistake which was done there. So I don't think that's an argument which is going to succeed in favor of the government and South Africa. It is a useless exercise, but I believe they may try to pursue it, because we don't want to accept we made a mistake and we want to correct it.
All right, thank you so much for your analysis. After that appearance before The Hague, that was Professor Shadrack Gutto from UNISA.